This is Where You Live with Gene and Tony. We're broadcasting from the Concierge Landscape Studios, and we're brought to you by Extreme Exteriors and American Family Insurance, the Kim Bennett Agency. Let's hear from the Community Associations Institute. The CAI Minute is brought to you by Start to Finish Maintenance Contractors. Start to Finish provides 24-hour service for all of your home and business maintenance needs. Call Start to Finish at 952-259-1219 for your home, for your business, for your peace of mind.
Are you a member of the Community Associations Institute? For nearly 40 years, CAI has provided education and resources to volunteer homeowners who govern community associations and the professionals who support them. Visit caionline.org to learn more. The address again is caionline.org. CAI helps community associations board members by providing online resources, in-person training, and hard copy publications written by association management experts. CAI offers community managers professional development, networking opportunities, and a certification program that is established as the industry standard nationwide. Minnesota has its own chapter of the Community Associations Institute to bring resources and tools from community associations around the country right to your home. Visit www.cai-mn.com to learn more and become a member of CAI today. Your community and management company will benefit from your involvement. Join the Community Associations Institute today at cai-mn.com and click on membership.
Well, Gene, it's our last segment. What are we going to talk about next?
Well, we've got one more story here, and this comes from the Florida Sun-Sentinel on April 4th, and it begins by asking a question. Are all legal opinions provided to a condominium board privileged information?
Now, we had a story about this issue last week, didn't we not?
And I came from Florida. I guess those folks don't know what a legal opinion is for down there, maybe. But anyway, I digress. The story says, recently in Florida, there was a unit owner who was present at their board meeting, and they suggested during the meeting that the board obtain an opinion from the association's legal counsel as to whether a membership vote was required to increase the budget. Good question.
Yeah.
Good request.
Yeah.
When the opinion was given, so apparently the board did got it. The board refused to share a copy with the unit owners, asserting it was privileged communication accepted from records inspection by the Condominium Act, and then they stated it.
Now, let me stop you here a minute. Isn't this what we discussed last time, that there was a decision in Florida that it was a privileged communication unless the board shared it with the other members? Isn't that right?
Well, that was a blog from an individual, wasn't? But
he said he had gotten that decision from a court.
Of course,
in his blog,
he didn't mention the decision or anything else. It was pretty. I thought it was pretty
anecdotal.
Yeah,
because I thought he had said that he got that decision in court where there was no longer attorney privilege in an issue because the board had shared the attorney's legal opinion with the rest of the members.
But yeah, I guess whatever the case there, we certainly took the position and said a legal opinion for the association is for the association. And then you have to ask yourself the question, who is the association?
That's right.
That would be all of the members.
That's right.
The association is not the board of directors.
That's right.
And, people need to remember there isn't a special class of citizenry called the board of directors. There's only one class of membership, and that is I'm a homeowner in the community.
That's right.
And you have the exact same footing, the exact same authority, the exact same responsibility. You have the exact same, understanding that you work from as all the other homeowners there.
So we think that attorney-client privilege should be maintained.
Yeah. I mean, let's take a look at this situation. The board is talking about whether they can raise the budget.
Right, which means raising the fees.
The
monthly
fees for everybody.
Yeah.
And a homeowner says, perhaps this needs to be done with membership vote. Well, why, if you were a board, I'm just thinking here in this particular case, why would you not share the legal opinion? If the legal opinion supported what you wanted, why wouldn't you share it? Because that would add credence, credibility, and authority to what you're stating as a board.
So you're thinking it indicates that the board was contradicted. The legal opinion contradicted the board, and so that's why they're not going to share it. See, my reaction
you don't need to see that. Just move away. Don't look at the person behind the curtain.
My reaction to this was, based on what we heard in that blog, the board was could be just concerned about sharing it with the board members because then they waive attorney-client privilege. Yeah. Now, that may be simplistic, but I thought that's what we were talking about last week, that the board may be risking losing attorney-client privilege if they share these legal opinions with everyone.
Yeah, I think the other thing that we brought out is that, and this is supported with Minnesota state statute.
Okay, all right.
That if the association board is going through a lawsuit at the time and they're in communication with the attorney. Yeah. At that point in time, they may have what's called the executive meeting. They may go into executive session where they take a look at information and don't make that known to the other homeowners. Not because they don't deserve to know, but because you're talking about winning or losing a lawsuit that could potentially cost the association thousands upon thousands of dollars. And so if that's the case, the association board has the right and authority to withhold that for a while. Once the decision has been made, there's no reason not to share that or not to share an opinion. So to me, it seems as if
you think it's very suspicious that they wouldn't share this opinion.
It makes me wonder if, like I said, you're right that it didn't support what it is that they
the
wanted.
Board wanted.
So they said, no, that's privileged information.
Yeah.
I bet you that was it. I'm guessing.
I have to say that's more likely. That's the most likely scenario that I can see. Yeah.
But but that's the question, that's being asked here, and I think we would say that is something that homeowners have a right to see.
Now, there was, they took it to arbitration, and the arbiter did make a ruling on this issue.
Yes, and it was in the case of Douglas Blass against the Illini Association. It says the arbitrator ruled that the association's discussion of whether it would be a prudent business decision to obtain a legal opinion waived the attorney-client privilege because the decision took place at an open meeting.
So now this arbitrator is saying the same thing. Attorney-client privilege was lost because the issue was shared with other homeowner association members. So that's really supporting what that blogger said last week. Yeah. They're losing attorney-client privilege by sharing legal information with all the members of the association.
Now, what's important for our listeners to remember is this was not a court case. This was arbitration.
Okay. All right.
And the distinctive there is when you go to court and you don't like the decision, you have the right for what's called an appeal. Costs more money, takes more time, but if you feel strongly that it was not looked at rightly, you can have a higher court take a look at it. And so then it goes to district court, and then after that it can go up, and it could go up to the Supreme Court if it
that's right.
If it was deemed
pushed.
But in this particular case, what's important about arbitration is not a necessary step. Arbitration is where two individual entities who have a disagreement say, look, we can't come to an agreement. We can't come to some sort of middle understanding. So we both agree to go to arbitration. And arbitration states that if I agree to go to arbitration and you do, whatever the arbitrator decides is going to be legally binding.
We'll abide by that. So it's a voluntary step.
It's a voluntary step, but because you go to that voluntary step, you're saying, I want to do it because I don't want to have to go through all this court costs.
Right.
So is the decision correct? Yes, because they
They agreed it
they
would be.
agreed that it would
Yeah,
be.
yeah.
Is the arbitrator thinking of case law? No, they're not going to be thinking
No.
of case law. They're thinking of they're coming up with a decision.
I see two issues here. Should the board share legal opinions with the members? In this case, we're suspicious that they didn't because they didn't like the legal opinion they got. So we think the board should share legal opinions with all the members because they're all part of the same corporation. They all need to know what's going on legally.
Yes.
Then the second issue is, do they lose their attorney-client privilege by doing that? So in this case, the arbitrator upheld that idea that they did lose attorney-client privilege because they even discussed the option of getting a legal opinion.
Yeah, but to me, we should have some of our other fine legal minds
I think
about it.
we need some finer legal minds.
Because I still have a hard time with it.
Well, you and
I'm
I
telling
both, after discussing the story this morning, we both said, this is really convoluted.
Yeah.
This is really twisted.
Yeah.
It's not shaken out. It doesn't make sense.
Yeah. Well, hey, that's all the time we have for today. Thanks for joining us. Have a great rest of your Sunday. We look forward to having you right here next Sunday on Where You Live.